Hello, my name is Michael Nowitzki and I'm a lawyer in the Hofmann Law Group. In our team we are working on international tax matters and international legal affairs. With the following video, we want to give immigrants some useful information for their life in Germany. Therefore we broach some legal aspects from the German family, employment, social security and tax law. For information for the inheritance law, please join our special video in this case. Let's begin with the German family law. When a married couple emigrates to Germany, of course their matrimonial property regime is not going to change thereby. Reason enough to give some information in this case. In Germany, the spouses live in a matrimonial property regime of the so-called Zugewinngemeinschaft if they have agreed nothing else. This has consequences also for the German right of inheritance, after which the surviving spouse per se gets just 1/4 of the estate. When the spouses lived in the mentioned matrimonial property regime, what is the rule in Germany? This part of the estate is increased by a further 1/4, which means that the surviving spouse finally gets the half of the estate. But be forewarned, if the spouses have not lived in this matrimonial property regime, or if the German law doesn't recognize the matrimonial property regime you lived in, the spouses part will not be increased. Let's come to the German employment law. As an employee in Germany, many laws offer you protection. For example, the Kündigungsschutzgesetz can protect you from unjustified terminations if you work in an enterprise with 10 or more employees. It is applied to employees who work at least 6 months in the same enterprise. It orders that contracts of employment can be cancelled just for some specific reasons. The Kündigungsschutzgesetz offers you a very wide protection, but be careful. You have to know how to use it. For example, you have only 3 weeks to bring an action in these cases. Besides this, a lot of other laws guarantee the protection of employees. The Arbeitszeitgesetz, for example, contains regulation concerning the maximum of working hours of an employee, or the Allgemeines Gleichbehandlungsgesetz, which is intended to prevent discrimination on grounds of racial or ethnic origin, gender, religion or belief, disability, age or sexual orientation. In addition, the Entgeltfortzahlungsgesetz regulates the payment of wages on public holidays and in case of illness of employees, and moreover, the Mindestlohngesetz guarantees a minimum wage of €8.50 per hour. Let us now come to the German tax law. When you live in Germany or when you have income there, you also are taxable in Germany. The German law distinguishes between the limited and the unlimited tax liability. If you don't live in Germany, you have just the limited liability, which means that just the part of your income you earned in Germany is taxable even there. When your tax domicile is in Germany, your worldwide income is taxable there also. The income from one or more sources will be determined after a deduction of a lump sum of the real costs. In difference to many other countries, in Germany you have to submit pieces of evidence for all deductions. Besides this, in Germany deductions can be made by tax credits and tax allowances. An advantage for an employee is, for example, that positive and negative income can be offset against each other indefinitely. The income tax rates range between 14 and 45%. In relation to many other jurisdictions, the German tax law gives you a lot of possibilities of deduction for personal reasons. The German tax law has different rates for married and unmarried partners. Furthermore, in Germany a so-called Solidaritätszuschlag is levied. This solidarity levy amounts to 5.5%. When you are working in Germany but living in a foreign country, you have just a limited tax liability in Germany. This means that your worldwide income is taxable in the country you are living, and just the income you earn in Germany is taxable here. In order to avoid double taxation, Germany has concluded double taxation agreements with many other countries. In relation to a dependent activity, in the most of these treaties is agreed that the work is just taxable in the state where it has been provided. Divergent from this, in most of these agreements, the country of residence has the right to impose a tax on the dependent activity when you live in Germany just temporarily and not more than 183 days of a calendar year, your work performance is paid by an employer who has got his residence outside of Germany, or your work performance is not paid by a permanent establishment which your employer has in Germany. In the end, let us give you some information to the social insurance. The EU Council regulation on the coordination of the social security systems holds significant importance. This regulation prescribes in which country an employee has to be insured. In principle, employees are subject to the regulations of the country in which they perform their duties. Under certain conditions, an employee who has been sent to another country may stay under the regulations of the country he originally performs his work. One of those conditions is that the employer's posting does not exceed a certain duration. To use this option, you have to apply for an A1 declaration at your Social Security. We hope that we have given you some useful information. Of course, these tips cannot replace a professional advice. If you need more help in these issues, please feel free to contact us. Thank you for your attention.